Okay, in this video I want to take a look at the Industrial Relations Act 1969 and the mechanism by which you can make complaints to the Workplace Relations Commission or the Labour Court under the Industrial Relations Act, which might not be possible under other acts. For example, if you feel you've been harshly treated in a disciplinary procedure, or if you feel that the bullying and harassment procedures in the workplace are inadequate, or if you believe that you're being bullied in the workplace, then you can, under the Industrial Relations Act 1969, refer a trade dispute to the Workplace Relations Commission for investigation. Now, there's a couple of problems with the Industrial Relations Act 1969. The first one is that under Section 13 of that Act, the Industrial Relations Act 1969, you can refer a trade dispute to the Workplace Relations Commission. However, all the adjudicator can do is make a recommendation. It's not legally binding, it's a recommendation. That's the first problem. The second problem is, and it's more likely to occur, if you make a complaint under the Industrial Relations Act 1969, the other party, the employer, for example, if you're an employee, can object to the Workplace Relations Commission hearing that complaint. And if that happens, that's it. The adjudicator cannot hear it. Now, you can go on instead and you can refer your complaint for investigation under Section 20, subsection 1 of the Industrial Relations Act 1969 to the Labour Court. And if the other party agrees to be bound by the finding of the Labour Court, then you have something to go on. However, the other party may not agree to be bound by the finding of the Labour Court. So even if you go ahead and even if you get a favourable decision that, for example, you were unfairly dismissed, and this referral under this particular act could happen if you have less than 12 months service. So in order to bring a complaint for unfair dismissal, ordinarily you need 12 months service. However, if you've been dismissed after 6 months or 8 months or 9 months or 10 months or 11 months, you don't have the requisite service for the Industrial Relations Act, for the Unfair Dismissals Act 1977, but you can bring a complaint or seek an investigation by the Labour Court under Section 20. The problem with it, though, is this: even if you're successful, the Labour Court's recommendation is also legally unenforceable. Now, it does have some value depending on the employer. If you have a small employer, for example, who couldn't care less about the Workplace Relations Commission or the Labour Court, and who is simply prepared to ignore the recommendation in your favour that you've been unfairly dismissed, well, that's it. It's game over for you as an employee. However, depending on your employer, the employer may well be embarrassed, for example, about any referral to the Labour Court, and it could be, or it is in public. So you may have a particular employer where you're able to inflict some moral pressure, some pressure on them with a recommendation, a positive recommendation in your favour, or finding in your favour in the Labour Court. Strictly speaking, it's not legally enforceable. But if you can imagine that you go along to the Labour Court, you have 10 months employment under your belt, you bring a claim for unfair dismissal, basically that you didn't get fair procedures and natural justice in the way that you were dismissed. You don't have the necessary service for the Unfair Dismissals Act. However, you bring a complaint because you feel very hard done by under the Industrial Relations Act 1969. The employer can very well just ignore it, not bother going along, or can go along and defend their actions. But if they don't go along and you win your case, and you're going to win it on the basis of your uncontested evidence, what you're going to have is a recommendation. The recommendation, as I said, is legally unenforceable. However, if it was a big employer who might be embarrassed or who might be fearful of, for example, industrial relations action outside the premises of the employer, then you might get more satisfaction, or you might get a better result or a better outcome. So there are certain employers who will be very, very concerned about you coming along and placing a picket outside the premises on the basis that you've won this case at the industrial or at the labour court, and that you're simply being ignored, that the company is ignoring it. Because some employers would be embarrassed about that, and some employers may have a highly unionised workforce. Some employers may be high profile, and so they don't want the publicity, they don't want the bad press, etc., etc. So you can refer complaints to the Workplace Relations Commission or the Labour Court under the Industrial Relations Act 1969. It is not of huge value to you as an employee, because essentially, A, you can be blocked in the first instance if the employer objects to any adjudication or hearing by the Workplace Relations Commission, and B, even if you're successful, your recommendation is legally unenforceable. The only way you can enforce it is by industrial relations action or means. So, you might be considering it because, for example, if you were dismissed, you were fired, you didn't get fair procedure, you were treated really, really badly, and you don't have 12 months service, then you simply cannot avail of the protection of the Unfair Dismissals Act 1977 because you need 12 months service. However, this is a way that might be of value to you depending on who the employer is. As I say, if the employer is a small employer and couldn't care less, then this is of no value to you. However, if it's a big employer, you may be able to exert some public relations or moral pressure on them. Hope you find this video useful. My name is Terry Gorry. I'm a solicitor in Enfield County Meath, do a good bit of employment law. If you think the video is useful, give it a thumbs up down below. Thanks for watching, and you might be interested in subscribing to my YouTube channel.